Thank you very much, Mustafa, for your generous introduction. Today, what I'm going to talk about is the need for reforming of the Companies Act. We have a very respectable panel with us today, and we have a house full of people who wants to hear about this need for reforming of the Companies Act. So, as you can understand, that I have 15 minutes to talk about the need for reform, so I'll get right to it. I have a presentation which basically summarizes what are the provisions that I will be looking at. So, starting from here, our primary legislation is the Companies Act 1994, and there's a rules which have been framed by the Supreme Court, which is the Companies Rules 2009. Bear in mind, these are not rules which have been framed by the government. That's something which I'll come up in the presentations. So, what is Companies Act? I'm sure everybody is aware, but the basic notion of Companies Act is basically, Companies Act governs companies. It tells you about the rights of the shareholders, the obligations of the directors, different disputes which arises within the shareholder, the filing requirements, the obligations to to hold meetings, notices, mergers, and so on and forth. But when it comes to reform, we have the 1994 Act, and now it's 2018. There has been a long due this reform. Around the world, we have seen different countries, the laws have been reformed, even our neighboring countries, which is India. Their Companies Act 1956 has been totally revamped by the Companies Act 2013, which by itself has been reformed twice, by an amendment in 2015 and also an amendment in 2017. So the key provisions, which in my point of view is which require reform, is in relation to simplification of businesses, the removal of burden of the court, increasing accountability, alternative dispute resolution, which includes shareholders' dispute in this modern era where we have mandatory mediation in the Code of Civil Procedure and the loan recovery in relation to the Doctrine Adalat Act. This is something which we can also think of introducing mediation, for example, before a shareholder brings the dispute before the court. The inherent jurisdiction and also the use of technology, because we know that by now, in this 21st century, the use of technology is immense. There's no need to have those typical notices to be issued. There's no need to have those publications to be issued for which, a simple notice not being sent by post cannot be a ground for the entire business of the company being held, the AGM being stayed, and all that. So these are, all for ease of doing business. The businesses needs to be accommodated rather than any sort of hindrance being brought in. The introduction of company secretary, which is in relation to public companies, fast-track amalgamations in relation to small companies, and also business exit in the form of winding up. I'm going to take you through each of these topics in relation to what reform is required. In relation to simplification of businesses, the current law requires every memorandum requires that any amendment or any in relation to the object of the company, as in what the company can do, needs to be clearly stipulated in the memorandum of association of the company. This, in general, is restrictive in nature. Why is it restrictive in nature? Maybe in 1994, when it was included, that was a thought for regulation of businesses. Maybe people needed to know what this company will do. But in this time, or in this modern time, you do not need objects of the company. The objects of the company should be limitless. It should be allowed to do any business which it desires, any legal business which it desires. So, what's my proposal? The proposal that I have, this is in line with the UK Companies Act, is the object laws of the company should be limitless. The provision which the UK's Companies Act includes is that unless a company's constitution specifically restricts the object of the company, its object should be unrestricted, which means that the company can do whatever legal business it desires. Secondly, another simplification of business which happens is that annual general meeting. We all know that, we all see, when we talk about the annual general meeting, anyone who has dealt with any private company or is a shareholder or a director of a private company, most of small family-owned companies see that the directors themselves are usually the shareholders. But the law requires that there has to be an AGM. What's an AGM? It's basically a meeting of the shareholders. So in closely held companies, there is no need for having AGMs. The directors itself holding a meeting, passing a resolution should be enough. But that does not mean that there is not going to be an AGM at all. What it means is basically that if the shareholders, if they come up with a resolution saying that we do not need any annual general meeting, a resolution of the director shall suffice for the purpose of annual general meeting, that should do it. But bear in mind, if the shareholder desires actually to hold an AGM, even after passing that resolution down the years, they can always seek it from the company. And the company shall in such cases be bound to hold an AGM. So there is another thing which I say, that in private companies, the resolution of AGM by circulation should also be allowed, which basically by circulation meaning that if it's a small company, there is no need for all the people to come in. We all heard about ease of doing business, in which it was told that sometimes the shareholders are not in the country, or they're not available to attend this meeting. That should not stop the AGM. If all the shareholders are agreed that by circulation a resolution can be passed, even if it's in the AGM, it's a general meeting, that should be allowed, but only in case of private companies. Moving on, this is basically a procedural thing that our Companies Act basically, Schedule 1 of our Companies Act contains model articles, and basically what it means by model articles is that these are the articles which are recommended by companies to incorporate in their articles. But there are mandatory forms of articles which are included even in those model articles. For example, Section 17 specifically says that those articles, as you can see, these are mandatory to be included in the article. So instead of those being included by reference, those should be brought in the Companies Act itself, and specific provisions should be included. Because these are important. For example, they cover proceedings of general meeting, they cover dividends, they cover accounts and notices of meeting. All these things should be brought in the Companies Act itself and made a provision in the Companies Act by way of reform. Next is the removal of burden of court. Now, as anybody who has been to the company court or practices company law knows that there are certain very administrative nature of cases which comes to the court regularly. For example, amendment of the object clause of the company. This basically, what does the court do? The court is required by law for a confirmation of the amendment. That when a company amends an object clause, it has to come to the court, file an application, get that application admitted, subsequently get it heard, and then the object clause, the amendment will be confirmed. This is a purely administrative nature. The court should not be burdened with such provisions. We all know that articles of association of a company can be amended by way of a special resolution. Special resolution meaning 21 days notice and 3/4 of the shareholders agreeing to that amendment. Similarly, in relation to the object clause of a memorandum, this should be done in a similar manner. Meaning, object clause should also be allowed to be amended by way of a special resolution, rather than forcing that company to go to the court for months together. Thereafter, what we see is the delay in registering charges. This actually happens a lot with banking and financial institutions. Whenever there is a charge or a mortgage which requires to be registered within, by law it's required to be registered within 21 days. Often we see the companies or the banks actually fails or oversteps that within 21 days. It becomes like a month or even 2 months. At that stage, what has to be done? The current law says you have to file an application before the court, and the court shall look into it and then affirm that, okay, then condone the delay to file that application, to register that charge, sorry. But what is required is that registration of that charge is actually the burden of the company as well as the individual financier. Because it's their obligation to have it registered. If a person fails to have it registered, actually the liabilities or the losses goes to that individual or that individual creditor. So what I propose is that the registrar should be allowed to condone those delays. In other jurisdictions, our neighboring jurisdiction, India, it actually gives 300 days for the registrar to condone this, to condone and allow that change. But what I would propose is 120 days, because 300 days is far too long for registering a charge. So within 120 days, with fines, of course, I have not written with fines, but with fines, they should be allowed, prescribed fines, they should be allowed to register that charge without actually burdening the court of this simple application. Now, the most important amendment is in relation to enhancing accountability. Enhancing accountability is vital because this basically is the corporate governance in relation to companies. What I propose is that the duties of the directors, we all know what are the duties, the fiduciary duties of the directors to its shareholders, to the creditors. But this should be codified in the Act. How it should be codified? The duty to act in accordance with the articles, the duty to promote the success, the duty to exercise independent judgment, the duty to exercise reasonable care, skill and diligence, and the duty to avoid conflicts of interest. This is extremely important, the conflict of interest and the related party transactions. We know that we are developing as a nation, we are developing, our companies law is developing, businesses are coming in, but I'm sure you agree with me when I say that conflicts of interest, we have little knowledge about conflicts of interest and related party transactions. This is something which is so important. This is something which is in relation to conflicts of interest. It is vital in any jurisdiction, advanced economy, you see that this is where it pinches. So this needs to be clarified in our law, that conflicts of interest and also related party transactions should be clearly stipulated, and the obligations of the directors to disclose should be clearly stated in the Companies Act. Thereafter, I have another proposal in relation to restriction of auditors. Restriction of auditors meaning that, for listed companies there is a restriction that for every listed company the auditors can only audit for 3 years. After the 3 years, the auditor has to change. In relation to private companies, there is no restriction. I understand that private companies, there is for ease of doing business, there should not be any hindrance and everything. But what happens that once an auditor is appointed in a private company, they go on forever. Their auditor, they basically become part of that company. But that should not be the case. My proposal is that their tenure should be also curtailed to 5 years. That after every 5 years, the auditor needs to change, because there needs to be a new set of eyes to look into the accounts of the company. That would basically increase the shareholders' accountability towards the shareholders as well. And then, of course, there can be a change after 3 years, that the same auditor can come back. Now, in relation to minority protection, we all know that there are many cases of minority protection in the courts, but minority protection, there is a typical hindrance in minority protection is that even if it's the majority does something, you have to have 10% shareholders have to come forth together to challenge that action. This basically, in a lot of instances, whenever we see that there is prima facie, there is unfairness, there is prima facie, the minority needs protection, but the court, even if they feel that, they are not able to do it because of the law, which specifically says that 1/10 of the shareholders is to come in. This needs to be relaxed. The court should be entrusted with the discretion upon an application whether to waive this requirement or not. The 10% can be there, but there should be a proviso where the court is entrusted in relation to giving that discretion upon the court to relax those provisions. And in relation to fines, I have 2 headings in relation to delay in filing annual return and default of auditors. The Companies Act 94, you would see that it's the fine very primitive. For example, a default of an auditor, even if in case of default, the highest amount of fine that can be imposed is 1,000 taka, which is absurd when it does not reflect the current rate. But in relation, even in our neighboring countries, this has been lifted to taka 25,000, taka 50,000 to taka 500,000. In their cases, it has been in rupees, but what we propose is that the fine should be enhanced. This should reflect that how the role of auditors are so important, that if in case of any default, that you are accountable for your default. You're not just a chopping house where you chop the accounts and it's fine. Of course, I have included a specific provision in there where it says that a specific provision may be included in the law, which provides a requirement for correlation between the penalty and the size of the company. Because, for example, a default of a listed company should not be equal to a default of a small privately held company. Inherent jurisdiction of the court. Now, inherent jurisdiction of the court is extremely important because this is basically what fills in the lacuna of the law. The court steps in and fills in the lacuna. What happens is that when it fills in the lacuna, this Rule 8 and Rule 263 in the company's rules, this provides that there are inherent jurisdiction of the court to pass any order for ends of justice. But these are all included in the rules. These are very vital elements. This should be included in the Act rather than the rule. So what I propose is that to bring it forward in the Act. Because we have seen in a recent judgment of a major two telecom operators amalgamating, in there, the court actually took a stand. The court basically forced the companies to have public hearing, which was actually a requirement. Court basically looked into the interest of the employees. And court passed an order to go and have a public hearing, come forward with what the employees will do in exercise of their inherent jurisdiction. So instead of, this is so important thing that this should be included in the Act. Moving on, electronic communication. In the 21st century, like I said, this is extremely important to have all sorts of electronic communication recognized in the Companies Act. We have heard that the RJSC allows e-filings, allows name clearance by online, but the Companies Act itself, they have to recognize this filing and reporting requirement through electronic communication. Our law still does not do that. Another very important thing is notices may be issued to the shareholders and directors by electronic means. That is, as long as the shareholders and directors are agreed. There's no need to post those notices. If they agree that you can receive those by electronic communication, that should be accommodated. And subject to limited exception, a company may be also allowed to convene board meetings by web conferencing or by teleconference. Bangladesh Bank has recently actually passed a BRP circular allowing this to an extent, but this should be reflected in the Companies Act itself. And of course, e-voting should also be introduced. In relation to companies' rules, as I've mentioned, the rules are a set of procedural guidelines which allows, the enactment of actual procedure, which allows the act to be in effect, right? But our rules, which we have, is basically the Supreme Court has enacted the Companies Rules 2009, which are purely procedural in nature. It sets up what? It sets up the forms which needs to be filled out, the way it's done, the notices which needs to be issued, and therefore. But what we actually need is basically the government of Bangladesh under the Companies Act to frame rules effectively for carrying out the provision. What kind of rules can be there? There can be rules in relation to incorporation, in relation to meeting of the board, appointment, qualification, dividends, amalgamation, and so forth. Moving on, there is a circulation of a document in relation to amendment of the that document. These are all the provisions which is included, but I would actually like to highlight that there are certain provisions in relation to amalgamation of small companies, which is extremely good. In relation to, there is a risky thing of majority 90% shareholder can buy out minority shareholders. That needs to be, I think, revised. There is a provision for investigation of offense by Anti-Corruption Commission, which is extremely risky, and I don't think that's something which should be included in the Act. Corporate governance, the SEC has corporate governance which is applicable for listed companies, which includes independent directors and role of senior management. These things should be included in the Act itself rather than being just a guideline, because these are very important. To conclude, a few words, what I would like to say is that our Companies Act, instead of amendment, we need a revamp of the entire Companies Act. Revamping means that there has to be a comprehensive law with flexible rule-making power to revamp the entire law. And there need not be, it has to be enabling business environment. I'm sorry, I ran out of time, I think, but I hope that it was helpful, and I leave it to the panelists to take it forward from here. Thank you.
Thank you, Margub. Margub has very ably given you an outline of what the Companies Act entails.